Welcome to the Scaringi Law Lunch Break. This is your time of the day to learn a little bit about the law while you enjoy your lunch. The pop star Katy Perry lost a huge copyright infringement case involving one of her biggest hit songs, the song Dark Horse. A California federal court jury has ruled that Katy Perry's Dark Horse was copied from a song written by artists including Christian rapper Marcus Gray, who performs as Flame, among others. The decision now moves the proceedings towards the damages phase, where Perry could face millions in penalties and the forfeiture of future earnings from the song. It's assumed that Perry will appeal the decision. Her attorneys are already petitioning the U.S. District Court judge to toss the jury's decision as meritless, given the evidence presented. The plaintiffs in the lawsuit are a Christian rap group. They wrote the song Joyful Noise, released in 2008, and claim that Katy Perry copied their song in her recording of Dark Horse in 2013. The pop star took the stand during the one-week-long jury trial. She testified under oath that she had never heard the song before. Other defendants claim the song Joyful Noise is too obscure to be noticed, much less copied. However, earlier in the case, the judge presiding declined to dismiss the lawsuit on those same grounds, stating plaintiffs have demonstrated a triable issue of fact as to access because Joyful Noise achieved critical success, including a Grammy nomination, and was readily available and viewed millions of times on YouTube and MySpace. That's according to the judge. So the judge did not rule that Katy Perry did hear the song, only that Katy Perry could have heard the song. Think about that. That's a tough decision for Katy Perry and for any artist out there writing their own music. You could be held liable for copyright infringement, even for a song you've never heard before, or for a song for which there is no proof that you ever heard before. It's just out there and accessible. So be careful. The issue in this case came down to the beat of the song, not the lyrics, the beat. The two beats are somewhat similar, but that's my opinion. You'll have to Google the two songs and listen for yourself. Now, I think what won the case for the plaintiffs and lost the case for Katy Perry is the plaintiff's expert. They used a musicologist. The expert sang numbers representing the pitch in each note of the two instrumental beats at issue, both of which have been previously characterized as an 8-note ostinato. In the expert's estimation, those ostinatos share 5 or 6 points of similarity, including pitch, rhyme, texture, pattern of repetition, melodic shape and timbre, or the quality and color of a sound. Did you know that a sound has color? I'm not so sure it does, but this expert found that they do. Additionally, he said the descending melodies of both ostinatos are unique. In studying the similarities between Dark Horse and Joyful Noise, the plaintiff's expert told the jury he had listened, hummed, sang along to, and played both songs at a piano, exercises that ultimately led him to determine that Perry and the other defendants had copied the underlying beat from the Joyful Noise track, even though there was no evidence that Katy Perry had heard the beat from the Joyful Noise track. Think about that. Now, Katy Perry's attorney argued that the beat and the song are derivative, and the beat is too common to be protected by copyright. He argued there's no copyright registration for the beat itself, which means that no claim for copyright infringement can be brought with respect to the beat. Now, his arguments fell on deaf ears with the jury. We'll see what the trial court does in response to the motion Katy Perry's attorneys have filed to set aside the jury verdict. If the court denies the motion, the case moves into the damages phase, and again, Katy Perry can be forced to pay millions in restitution. But let's just go over a few basics on copyright law. Pennsylvania recognizes a common law right in artistic production, meaning authors have ownership of their works even if they do not register them. The common law property right is held by the author or artist in his or her work or design. Under common law, rights in literary or artistic work are recognized on substantially the same basis as title to other property. So if you write a song, you have the same right of ownership in the song under Pennsylvania common law that you have if you own your home and your name is on the deed to your home. But to be protectable, the song must be original. What's original? That's the $64,000 question, or in the Katy Perry case, the $64 million question, perhaps. Pennsylvania defines original as something created without copying. Kind of a redundant definition, right? So long as the work is not copied or plagiarized from a former work, it need not differ substantially from a prior work. A copyright gives protection from copying only. A person working independently would not infringe a copyright even though his or her resulting work was substantially identical to a copyrighted work. And that's what Katy Perry was arguing, that she was working independently and did not copy or plagiarize the song Joyful Noise. But the jury ruled against her on that. And you can see how technical these cases get on copyrights with regard to songs, and how very close these cases are. Now Google the songs Joyful Noise and Dark Horse, and you be the judge. If you're involved in a copyright dispute or would like to learn more about copyright law, give the attorneys here at Scaringi Law a call for a consultation at 717-657-7770. We'll be happy to help and provide you with assistance or representation, whatever you need. Well, I hope you learned a little bit about the law. Thanks for listening.